appeal partner in the matter of Mueen-Uddin and Secretary of State for the Home Department.
Yes, Mr. Hudson.
Good morning. My lady, my lords, what I propose to do this morning, if I may, is deal with the following matters. I was going to refer to the decision of Takar, which my Lord Justice Phillips pointed out to me yesterday. I would just like to make a few brief observations about that, if I may. And I hope copies have found their way to the court. I know my Lord Justice Phillips obviously has a copy.
I was looking at it online, actually.
Yeah.
I'm afraid a copy.
Well, we brought hard copies. Thank you. We brought hard copies. If I may just make some brief observations about that. Then I wanted to...
Do you want to give my Lord Justice Dingemans a reference, because obviously we can't reach through the screen. Give him any copies.
I know efforts have been made to send an electronic copy, but the reference, my lady, my lord, is 2020 appeal cases 450. And I'll come to that in a moment, if I may. Then I'd like to say some concluding observations about ground 4. And then when I've done that, I propose to take grounds 5, 6, 7 and 8 in turn, and then finish with relatively brief observations about the respondent's notice. So that's my intended plan, and I am aiming to finish no later than 12 o'clock.
Thank you.
So as to give my own friend an opportunity to reply to the extent he needs to.
Thank you.
So may I start with Takar?
Yes.
As I say, it's a decision of the Supreme Court 2020. The case involved a claimant alleging that various properties had been fraudulently taken from her, and it involved a question, by the time it got to the Supreme Court, a question of whether or not, in order to be able to bring a claim in fraud, the claimant had to prove or demonstrate that there was evidence for the fraud which she could not have obtained with reasonable diligence before bringing the claim in fraud. And it was in consideration of that issue that their lordships considered the dicta of Lord Templeman in the case I relied on yesterday of Owens Bank and Étoile. And as my Lord Justice Phillips pointed out yesterday, the Supreme Court did not follow the approach in Owens Bank, or the dicta in Owens Bank, and held that a different test should be applied when it concerns questions of fraud, such that the reasonable diligence test should not apply in fraud cases. And one gets that conclusion from paragraph 54 of Lord Kerr's speech, which is at page 476 of the report. I do not consider that Étoile and Bracco are, Étoile that I cited yesterday, are authority for the proposition that in cases where it is alleged that the judgment was obtained by fraud, it may only be set aside where the party who makes that application can demonstrate that the fraud could not have been uncovered with reasonable diligence in advance of the obtaining of the judgment. If, however, they have that effect, I consider that they should not be followed. In my view, it ought now to be recognised that where it can be shown that a judgment has been obtained by fraud, and where no allegation of fraud had been raised at the trial which led to that judgment, a requirement of reasonable diligence should not be imposed on the party seeking to set aside the judgment. And Lord Sumption agreed with that, gave a additional judgment, which I'll come to in a moment. So the main point I wanted to make about it was that what it doesn't do, as it seems to us, of having had an opportunity to look at it overnight, it does not concern or touch on the principle I relied on or sought to derive from the Owens Bank case yesterday as to whether or not foreign judgments could be taken into account on an abuse of process application. But for the sake of completeness, it is worth noting that both in the speech of Lord Kerr and in the speech of Lord Sumption, there is reference to the test as applied in the Hunter case. And the court may find that of assistance. And what, in summary, what both Lord Kerr and Lord Sumption observe is that the test for impeaching a judgment on grounds of fraud on the basis of new evidence is different and distinct from the test in cases of Hunter-type abuse as to whether or not a claimant comes within the exception of fresh evidence. And we haven't touched on the issue of fresh evidence in a Hunter-type case in this court, although it was a live issue before Sir Andrew Nicol, but that ground of appeal that hasn't been pursued on appeal. But it is perhaps instructive to note the way in which the Supreme Court dealt with this issue and observed the test is stricter, or acknowledged the test is stricter in a Hunter-type case than it is in a fraud-type case, for understandable, if I may say so, public policy reasons. And the passages that I particularly rely on to make that point are in Lord Kerr's speech at paras 37 to 39, where there's a general discussion about Hunter. That's at page 471, F onwards of the report. And this can be particularly seen at paragraph 39 of Lord Kerr's speech at page 472b. The context of the issue in Hunter is therefore firmly set. It is whether a challenge to the correctness of a criminal conviction amounts to an abuse of process. This is self-evidently an entirely different situation from that which arises in the present case. And it immediately gives rise to concern about whether it is acceptable to apply a test fashioned for the circumstances of collateral challenge to a criminal conviction to the markedly dissimilar setting of seeking to set aside a civil judgment because it was obtained by a fraud which had not been alleged or adjudicated on at the original trial. And then at 65, Lord Sumption also considers Hunter. That's at page 479c, and says this: dicta apart, the only direct authority for a requirement that the new evidence should be such as could not with reasonable diligence have been deployed in the earlier proceedings, that's in the context of a fraud case, is McElkenny affirmed Hunter and Chief Constable. And then Lord Sumption explains what the case was about, and then at E, the actual decision is distinguishable on a number of counts. The earlier proceedings were criminal. Moreover, the result of the civil action, if it had succeeded, would have been to discredit a subsisting conviction without setting it aside. And then explaining why there is a different in approach to fresh evidence, if I may call it that. Lord Sumption says at G to H, it may well be that policy considerations justify such a principle where a collateral attack is mounted on a criminal conviction following a trial in which the same issue was decided. There are other procedures for reopening unsafe criminal convictions in such cases. As is well known, these were ultimately invoked and resulted in the convictions of the plaintiffs and McElkenny and Hunter being quashed. I would respectfully decline to treat the statements in those cases applying to proceedings to set aside civil judgments, and would hold that the dicta in the two Owens Bank cases were mistaken. And that echoes, we submit, the observations made by Sir Thomas Bingham in the Smith and Linscall's case about the procedural safeguards in criminal cases such as to justify a different approach in cases involving a collateral attack on a criminal judgment as opposed to impeaching a judgment for fraud. It's perhaps worth reminding the court that although in the court below the appellant raised the question of fresh evidence, and we relied on the phosphate sewage test as to demonstrate why that didn't work. That hasn't been raised before this court. It's not being alleged that there's fraud, so the fraud test doesn't apply. And I did observe yesterday that my learned friend said in his submissions that when he was referring to parts of the ICT judgment and the affidavit that my Lord Justice Dingemans referred to, that my learned friend said he was not relying on that to show that the conviction was unsafe or unfair, but simply to demonstrate there were peculiarities, I believe his word was, peculiarities in the ICT procedure. So, my Lord Lords, I thought it might be helpful, following the prompting of my Lord Justice Phillips, to look at that case in a little more detail.
Thank you.
Having done that, may I turn to a concluding observation about ground 4, which I had essentially finished yesterday. But I would like to remind the court of the ambit of that ground. And the grounds of appeal, the original grounds of appeal, are in the core bundle at tab 1, and the grounds are at C13. The amended grounds, which is simply at ground 8, are at tab 11. Ground 4, if the court's looking at tab 1, is at C14. And we do say it's important to note that the ambit of this ground is confined to the manifestly unfair limb of the Hunter test, if I can describe it as that, despite everything I said yesterday about not reading it as a statute. And one gets that from ground 4 itself. The major argument on ground 4 is that it's the vexed twice argument, which we say is wrong as a matter of law. But the alternative argument under ground 4 is if the vexed twice argument isn't right, and therefore the learned judge was entitled to take into account any manifest unfairness or unfairness to the defendant, then it was wrong in principle and on the facts to strike out the claim as unfair to the respondent. So obviously it must be said it's plainly wrong. So we do contend that ground 4, it is clear, we suggest that ground 4 is only challenging that part of the judge's decision to strike out on the grounds of manifest unfairness to the defendant, as referred to in Lord Diplock's speech in Hunter at page 536 C to D, which I know the court's been looked at many times already. It is not, it seems to us, an attack on or concerned with that part of the judge's judgment that found that the pursuit of the appellant's claim, if allowed to continue, would bring the administration of justice into disrepute among right-thinking people. And it appears to us, from looking at the grounds carefully, there is in fact no appeal to the judge's finding that it would be an affront to justice or the claimant's claim to proceed, and therefore it follows that it would bring the administration of justice into disrepute among rights thinking people. And for the court's note, the learned judge referred specifically both to unfairness and to affront to justice, which is clearly the second limb of Hunter, at paragraph 83, Roman numeral 5c of his judgment, which is at tab 8 of the core bundle, page C85. And I make the obvious point that either of those limbs is sufficient for a claim to be struck out on the basis of abusive process, particularly on the basis of the Hunter type abuse. May I then turn to ground 5? Ground 5 is at C14, page C14 of the core bundle. It's dealt with in the appellant's skeleton argument at paragraphs 42 to 45, and in the respondent's skeleton argument at paragraphs 48 to 51. I don't propose to take the court to those paragraphs now. I know the court will have read them. The essence of the complaint under ground 5 is that the judge's reliance, which is the word used by the appellant, on other continuing publications was an error of law. So it seems to us that the appellant's position, in order to have any hope of succeeding on this, must be, therefore, that the judge was not, as a matter of law, permitted to take into account the continued publications when deciding whether or not the appellant's claim was an abusive process. We submit this ground fails for two reasons. A, it in fact misunderstands and mischaracterises, critically mischaracterises, the approach adopted by the learned judge. And B, it is wrong as a matter of law in any event. Dealing with those in turn, we say it mischaracterises the approach adopted by the judge, and that becomes clear both from my learned friend's submissions yesterday, but when one looks at the appellant's skeleton argument. And so I do need to take the court to that, please. It's the paragraph I'd like the court to look at, please, is 43, which is at page, it's tab 12, C122. And so at 43, under ground 5, it is said the judge took into paragraph 83.12 of the learned judge's judgment, the judge took into account the applicant's Wikipedia entry and the fact that, quote, the publicity which followed his conviction, end quote, would be unaffected by this libel action as a reason why the applicant vindicating his reputation was of little importance. Now, we submit that clearly mischaracterises what the learned judge was doing at that part of his judgment. Because the judge was not doing what he is accused of doing in paragraph 43 of my learned friend's skeleton argument. And that becomes clear when one looks at the relevant paragraph, which isn't in fact quoted in full, of the judgment, and it's paragraph 8312, and that's tab 8, and 12, paragraph 12, 8312 of the judgment is on page C87. And it's important to read it in context to see what the judge was actually taking into account and was actually deciding. And halfway down 12, the judge says, no doubt as well the change, i.e. the deletion of the words complained of following correspondence and before the issue of the claim, had the consequence that the claimant does not seek an injunction by way of relief in these proceedings. The consequence is, obviously of not seeking an injunction, is that even if the claim is successful, the earlier publicity, including his entry on Wikipedia, can remain. The publicity which followed the claimant's conviction and sentence can continue unaffected, and others would have a qualified privilege defence to any claim for libel. The learned judge then refers to the extent of publication. Downloaded just under 5,000 times, but no necessary inference the persons read the very limited passages which constitute the words complained of. Only a handful of copies of the hard copy version of the original report were distributed. Mr. Dean submits that this is a very serious thing for a government department to label someone a war criminal. So it would be, but the features to which I've drawn attention mean that other factors have to be taken into account in weighing the importance of the claimant being free to vindicate his reputation. That, as we understand it, is the bit, the part of the judgment relied on by my learned friend to make the submission in his skeleton argument that the judge had ruled that the appellant vindicating his reputation was of little importance. And we submit it's clear that the judge simply was not deciding that or reaching his decision on that basis. What the judge was clearly doing, and we say he was entitled to do as a matter of law, was weighing all of these material factors, including the continued publication, which could not be stopped, in deciding whether or not it was an abusive process. And as part of that, the judge had to consider and weigh the importance of the claimant being free to vindicate his reputation, therefore the importance of the claimant's claim being able to proceed. The learned judge did not describe it as being of little importance. We submit it's clear the judge gave it the appropriate weight and considered it as a part of one of the many material factors. So, firstly, as I've already said, it mischaracterises and therefore is simply wrong as to what the exercise the learned judge carried out. But secondly, it is wrong as a matter of law for it to be said that the judge was not permitted in law to take into account the continued publications.
Mr. Hudson, just before you go to the second point and what the law is, can I just ask you about that passage that the judge set out there? He referred to qualified privilege for other publications. I know we haven't got a defence in this case. Are there issues of qualified privilege that arise in relation to the government publication?
My Lord, it is a defence which is open to the defendant to rely on qualified privilege.
But it formed no part of your application for reverse summary judgment in this case?
No, it didn't.
Okay, thank you.
So, well, Lady, my lords, we say the issue of law advanced by my learned friend is simply wrong. Our position is that the learned judge was entitled, not only entitled, but had to take into account as one of the many factors, the multi-factors, the nature, amongst other things, the nature of the words complained of, the extent of publication, which is all dealt with in summary of 8312, the fact and consequence of the appellant not seeking an injunction, and, just as importantly, albeit it's a matter of weight, the nature and extent of other publications which made the same or similar allegations which would continue to be published even if the appellant's claim proceeded and was successful. So even if he succeeded on both his libel claim and his inaccuracy claim under the Data Protection Act, it would have no impact at all on the continued publications. And the learned judge was not, as a matter of law, precluded from taking that material into account on an application to strike out for abuse of process. My learned friend, in his skeleton argument at 43, which is the paragraph I've already referred the court to, the last, in 43, my learned friend relies on and asserts that such an approach by the learned judge was contrary to the rule in Dingle. And then in his final sentence of 43 says those principles of law and evidence equally apply when assessing hunter abuse, insofar as elements of proportionality can be properly taken into account. The point was addressed directly by Mr. Justice Warby, as he then was, in Le Chaux, and the Supreme Court approved the approach of the judge. That is wrong. The point was not the point, which can only mean whether or not a judge can take into account continuing publications on a hunter type abuse application and or is bound by the principle in Dingle, was simply not considered by Mr. Justice Warby in the show and the Supreme Court. It is wrong to say that. What my learned friend is doing is he is seeking to apply by way of analogy the treatment of the Dingle principle by Mr. Justice Warby, as he then was, and the Supreme Court in Le Chaux on the question of serious harm to the issue before this court and before the learned judge.
Can I just ask, while we're still looking at 4312, where the judge refers to the Wikipedia entry, is it your contention that that is evidence of general reputation for the purposes of the Dingle rule?
Well, my lord, I may make that submission. I don't have to make that submission for these purposes, because my submission is that the Dingle rule does not impact on the decision a judge or a court has to make when considering an abusive process application under Hunter grounds or whichever other grounds the court is considering. Because the issues are quite different and distinct, and ultimately the policy reasons behind the Dingle rule we submit do not apply to the issue before the learned judge and before this court.
It would be slightly unusual to have a strand of jurisprudence in libel proceedings which applied for one purpose but not another.
Well, Well, we say where the issues are very different and distinct, as they are, we submit in this case, it is understandable and permissible for different approaches to be adopted, because, as I've already said, the policy reasons behind the Dingle rule and its extension, if I can describe it as that, to the issue of serious harm are very different from the multifactorial exercise a judge has to carry out when considering abuse of process.
Thank you.
So to develop that, the reasoning behind Dingle and its application to mitigation of damages and serious harm, we submit clearly does not, certainly not necessarily, and we say it would be quite wrong for it to apply to the question of whether or not it was manifestly unfair or would bring the administration of justice into disrepute for a claim to proceed in the context of continuing publication. And we do submit that when considering whether or not it would bring the administration of justice into disrepute among right-thinking people, the idea that the court would have to ignore, or has to ignore, and cannot, as a matter of law, take into account, for the examples in this case, the conviction, the detailed judgment of the ICT, the dispatches programme from 1995, all of the publicity following the conviction, including the claimant's Wikipedia, or the Wikipedia entry relating to the claimant. Right-thinking people, we say, would be horrified at the idea that that material, which anyone can read at any point or watch, has to be ignored by the court in deciding whether it's manifestly unfair or would bring the administration of justice into disrepute. Because they would take into account, of course, well, if a libel claim, certainly one such as this, is going to occupy a large amount of time, going to cost a large amount of money, whatever the precise parameters of it are, it's very difficult to suggest otherwise. But at the end of it, nothing has changed in terms of what can be published by the rest of the world. We do submit that the right-thinking person would be horrified at that idea and would think libel law was completely bonkers. Sorry, I shouldn't use.
Wouldn't be the first person to use that word in the context of libel litigation. There we go. Yes.
Well, Eddie, it's probably better if I move on rather than my inappropriate epithets to the decision of Mr. Justice Simon, as he then was in the case of Karpov, because we say that decision makes it clear that Malona's friend's submission is wrong in law. Karpov is at tab 36. Decision of Mr. Justice Simon, as he then was in 2013 EWHC 3071QB. This was a case involving very serious allegations of kidnap and torture and murder having been made against the claimant, and one can see the nature of the allegations made against the claimant at paragraph 40. Page 1039 of the electronic bundle. Sorry, not paragraph 40, paragraph 10 starts to summarise the nature of the allegations, and then at 11, the defamatory meaning is pleaded. Paragraph 40, which is at 1039, sets out the nature of the application made by the defendants to strike out the claim. And at 42, paragraph 42, 40 subparagraph 2, one of the grounds was that the claimant can achieve no worthwhile vindication in these proceedings given the torrent of international condemnation of the Russian officials, including the claimant, who were involved in the events leading to Sergei Magnitsky's death. The English court cannot restrain the continued publication of reports condemning the claimant's conduct or direct the removal of the claimant from the Magnitsky list, and any limited vindication that the claimant might achieve is wholly disproportionate to the cost of the exercise and the burden on the court's time. That was one of several grounds on which an application was made to strike out. The decision on the issue was given by the learned judge at 74 of the judgment, which is, or the start of it, which is page 1046 of the electronic bundle. 74, Mr. Justice Simon said, "It is common ground that vindication of a claimant's reputation and the opportunity to prevent repetition of the defamatory material lie at the heart of a claim for libel." 75, if the proceedings are not serving the legitimate purpose of protecting the claimant's reputation, the court must bring the proceedings to a stop, see Jamil. Then at 76, defendants submit the claimant will be unable to obtain any worthwhile vindication. 77, there is a description of the evidence which made allegations in relation to the claimant in that case. And at 78, it said the cumulative effect is described by counsel for the defendants as, quote, an unstoppable torrent of international condemnation of the Russian state and of the public officials, including the claimant involved in the events which led to the death of Mr. Magnitsky. There is then detailed consideration of the issue, of issue 2, at paragraph 88 onwards, page 1049. And then at 88, Mr. Justice Simon said, "I accept that part of the purpose of these proceedings is the vindication of the claimant's reputation, particularly in relation to the most serious charge, criminal complicity in the death of Sergei Magnitsky, and that the court must proceed on the basis that the dissemination of a libel in other publications is legally irrelevant to the award of damages. Therefore, the Dingle principle applies." Then at 90, on the other hand, it may, at least in principle, be relevant to an abuse of process application and the consideration of whether the continuation of the proceedings would serve the legitimate purpose of protecting the claimant's reputation, to consider the nature of that reputation in the light of matters of which no complaint can be made because they occurred either outside the jurisdiction or before the period covered by the claim. This approach does not involve an infraction of the rule on damages set out in Dingle. It is recognition of the realities of the case. It seems to me to be highly unlikely, for example, that the inclusion of the claimant's name on the Magnitsky list would be affected by any finding of this court for reasons that I have already set out. This is a matter to be borne in mind in the context of the claimant's wishes and the substantial cost of what is likely, subject to the claimant's application, to be a long trial. So we submit it's clear from that Mr. Justice Simon did not consider the Dingle rule to be a bar on consideration of that material in exactly the same way as Sir Andrew Nicol took it into account in the present case. The claim was, for a number of reasons, but including that issue, struck out, and for the court's note, the conclusions start at the bottom of page 1057, but already over the page at 1058 from paragraph 138 onwards. And I refer the court in particular to paragraph 140 at 1058, in which Mr. Justice Simon considered the extent of any vindication which could be achieved, and the impact of any judgment, despite the fact there were considerable publication of other damaging allegations which could not be prevented. I also refer the court in relation to the Jamil question, which we're going to come to 144. Finally, there is also the matter of the cost of a trial. The fact that 14 bundles of documents were thought necessary for the disposal of these applications before disclosure has been given is an indication of the likely cost which would be incurred and court time which would be required for a trial. And then at 145 the claim struck out. So, my lady, my lords, we do submit that as a matter of law, the learned judge was entitled, and we say he had to. It would have been wrong of him not to have taken into account the material that could and would be continued to be published. And there is a very, very substantial amount of material. And going back decades, going right back to shortly after the events in December 1971, but perhaps for the purposes of this jurisdiction, particularly compelling is the dispatches program in 1995, which makes it clear, well, says the appellant was responsible for these murders, and includes the interviews with eyewitnesses at the time, and right through to the conviction, the judgment of the ICT, and then all of the publicity afterwards. And those are matters to be taken into account. Now, the appellant says, well, if the appellant is wrong as a matter of law on this issue, and the judge was entitled to take into account, the judge nonetheless erred because he did not consider the specifics of the articles, and seems to be suggesting that the learned judge did not take sufficiently into account the fact that a large number of the articles post-conviction refer to the denials of the appellant as to his guilt, and refer to questions having been raised about the alleged procedural flaws in the proceedings of the ICT. We submit that that in reality is simply attacking the weight the learned judge applied to these matters. It's not a proper ground of appeal. It is from a review of the judgment in any event wrong. The learned judge was fully aware of that submission that was made by my learned friend before the learned judge. The learned judge was fully aware of it, took it into account as he ought to have done as part of one of the material factors. Some of the reports, as we set out in the skeleton argument, don't contain such denials. But these are all matters that are all being put in the balance and weighed against one another to see where it comes out, which is precisely what the learned judge did. Ground 6, if I may. It's in the application, the appellant's notice at C14. It's dealt with in the appellant's skeleton argument at paragraphs 46 to 52, and in our skeleton argument at 52 onwards. There are three elements or complaints under this heading. This is the Jamil ground, if I can call it that. But there are three elements, and we say none of these indicate errors of law, nor do any of them indicate that the judge was plainly wrong, took into account immaterial factors, or failed to take into account material factors. The first one is that the learned judge did not provide any sufficient basis for the exercise of the Jamil jurisdiction. We submit one only has to read that out to appreciate it is not a ground of law, it is a weight issue. Secondly, the learned judge placed emphasis only on the length and cost of the trial and did not apply the correct test as to whether the claim could be adjudicated in a proportionate way. Again, we do make the obvious point. An appeal based on a question of emphasis is perhaps not the most promising of starts. The third complaint is that the learned judge downgraded the importance for the appellant in vindicating his reputation on the basis of the alleged, we say, error, or the error of law which the learned judge is alleged to have committed, which is set out in ground 5, the ground I've just dealt with. We contend all of those are wrong, and if I may take those briefly in turn. So first, sufficient basis. The learned judge's reasoning under the heading of Jamil abuse comes at para 84 of his judgment, which is at tab 8C88 of the bundle. Now, it is, we submit, obvious that the reasoning of the learned judge on Jamil abuse, set out under paragraph 84 onwards, has to be read in and understood in the context of the judge's earlier parts of his judgment. And the reason for that is that these are overlapping factors and considerations. And we say it would be wrong if it's being suggested that the only matters the learned judge took into account were those at 84. Even if that is what the learned judge did, we say that disclosed no error of law and doesn't mean he reached the wrong decision, and doesn't mean he didn't give sufficient reasons. But it's clear that it isn't what he did. The learned judge clearly took into account all of the matters he had set out in all of his judgment in considering the question of Jamil abuse. The learned judge, we've set out the scale of argument, but I'll summarise it. The learned judge, we say, referred to and properly took into account when considering Jamil abuse the following matters. Critically, the fact that the truth and accuracy of the ICT's conclusions and finding of guilt would be squarely an issue in the claimant's claim. And that determining that matter, that issue, truth and accuracy, would be lengthy and costly. And that's the lengthy and costly is dealt with in both paragraphs 85 and 89 of the judgment. At 85, the learned judge referred to the cost estimate given by Miss Amini of 750,000 to £1 million. And that's dealt with for the court's note. It's in paragraph 53 of Miss Amini's first witness statement, which is in tab 1, the supplementary bundle, tab 1, page S23. And the judge was, we say, right to take into account those estimates. The reality is, we say, in a case such as this, albeit at an early stage, I acknowledge it's an early stage, in a case such as this, it is obvious that if the central issue had to be litigated, it is not going to be cheap. whether it's 500,000 or 750,000 or $1 million, doesn't really matter. The vice is the same in the context of a case like this. And in addition, we say, in considering proportionality, which is obviously one of the central issues to consider under Jamil abuse, the learned judge rightly took into account the matters he set out at J83:12 of his judgment. And we say that because at 83:12, page C87, the judge does refer to a sense of proportion being important. We say that's clearly a reference to the proportionality, in part, proportionality of the proceedings. And then the learned judge set out at 83:12, amongst other things, the matters the court's already aware of, the fact that the online report had been amended before proceedings were issued, no injunction was sought, the point we've already made about extensive publicity remaining, a relatively limited publication, the fact that it can't be assumed that everyone who downloaded it managed to get through all the pages to the footnote and read it. It's a very unlikely thing to have happened. And those were all matters which the learned judge was right to take into account, did take into account when considering the question of Jamil abuse and the issue of proportionality, whether the game is worth the candle in terms of the vindication that the appellant could achieve if these proceedings continued.
Can I ask in terms of what the trial would involve?
Yes.
And we have a guide. We know what happened in the ICT proceedings. And there's plenty some reliance there on documents.
Yes.
Newspaper reports, which, for what they are worth, evidentially would be available.
Yes.
And we know that there was one eyewitness.
Well, there were, if memory serves, there were either 21 or 25 live witnesses called. No, I'm not saying eyewitness, my lord. Live witnesses called, of which some, more than one on our analysis, was an eyewitness. Now, one can debate whether they were an eyewitness or how old they were, whether they're even alive now, all of those sorts of issues. But there were, I can't remember, it's either 21 or 25 live witnesses called on behalf of the prosecution in the ICT.
The claimant wasn't the only defendant in this proceeding.
No, there were two defendants. There were two defendants.
Well, it just seems to me I understand you can come here and say, well, this is going to be a very large trial, but if one drills down into it, what actually is your case? Do you expect you would be calling lots and lots of witnesses? It doesn't seem to me you would be.
Well, my lord, to prove the truth of the allegation, one would try inevitably. Well, the starting point would be the approach adopted at the ICT and the witnesses called, to the extent any are still available or alive. There is I accept we're at an early stage of this, but my lord, we say.
Well, you have said that you would justify. So you must.
Yes.
You must have formed the view that there is material there that you could call to justify.
Yes.
So what is that material?
Well, it's the evidence of witnesses as reported in the ICT judgment, the documents. There is material which I've said repeatedly in the Channel 4 Dispatches programme, which is significant material as to eyewitness accounts of the appellant's participation, not just responsibility for, but participation in the abduction, torture and murder of some of the intellectuals in December 1971.
What you can't do is, at the moment, is give us a list of people that you
No.
might potentially want to call, nor how many there will be.
No, my lord, I don't. No, and one of the reasons Well, we brought the application at this relatively early stage because it seemed to us, well, in a case which we contend this is, where we submit, it is clear that if this issue is permitted to go ahead and be litigated, on any analysis, it is going to be very expensive and time-consuming. Libel cases tend to be very time-consuming and expensive, even relatively straightforward ones. And my lord, we do say it's not just about the trial process. It's not just about the trial itself. Obviously, the trial is very expensive, but the costs are enormous, as the court will know, does know. The costs are enormous in the run-up to the trial. And what we've tried to do, bringing it this procedurally early stage, if I can put it that way, is to stop this at this point before enormous costs are run up. Even in pleading.
Well, obviously, the court has experiences in relating law, and that all those in the court do too. But also an experience that sometimes parties come along and say, "This is going to be horrendously expensive, massive disclosure, huge number of witnesses." But when it actually comes down to it, it transpires that it is not so. And I think usually what the court expects, before it accedes to the in terrorem argument, is a degree of specificity, particularly if it's used as part of a strikeout application. Right? Coming on and saying, well, one knows that these sort of actions will be huge and hugely expensive.
Yes.
For my part, doesn't cut much ice.
No. I
need to know a little bit more before I will accept that a claim as to what happened in 1971, which, on the face of it, has very largely based on hearsay accounts. What is that going to involve in terms of an English trial? At the moment, I don't understand why this would be a huge and expensive trial. It might be, I agree, it might be, but it doesn't seem to me we've got any evidence to support that.
Well, Lord, the evidence before the learned judge was that set out in Miss Amaney's witness statement, which I referred to.
One last paragraph.
Yes, about the cost.
You have no details at all.
No. The learned judge was a highly experienced judge, is a highly experienced judge in this field. And we do submit the court can and ought to take that into account when considering issues of appeal and whether or not the court should interfere with the learned judge's decision. And as I pointed out in the decision of Mr. Justice Simon, as he then was in the Karpov case, Mr. Justice Simon took into account the number of the 14 volumes that were before the court on that application.
How many volumes were before the judge on this application?
Certainly not 14, because I work electronically. I can't, but I accept nowhere near 14. But the point I'm seeking to make, my lord, is that yes, of course, on some occasions, and perhaps many occasions, the court will expect a much more detailed evidence. May even say, well, unless and until a defence has been filed, we can't embark on this exercise. I accept that, of course. Our submission, as it was before the learned judge, was that in this case, because of the unusual circumstances of it, the court can realistically and sensibly anticipate that the costs, however it pans out, are going to be very substantial. May not be $1 million, maybe $500,000, but we say that doesn't really matter when weighed against the other issues which the court has to take into account in deciding Jamil on the questions of proportionality. And so, and particularly, as the learned judge took into account, well, and Friendly says he wasn't permitted, but we say he was permitted, to take into account what could be achieved by this claim in the same way as in the Karpov case. And we say very little in reality can be achieved by way of this claim, the outcome of this claim would have, we submit, actually no significant impact on the appellant's reputation in the context of everything else that has been and can continue to be published. So, whilst of course I accept my Lord's observation about the need for more specifics, that would apply in most cases, we do submit that in some cases, this being one of them, that the court can adopt a more broad brush approach based on everything the court knows about the case and about libel litigation generally.
Let's go back to the question about what might be achieved here. Do you not accept that there is a quite significant distinction between publicity that the appellant had been convicted in a tribunal which was internationally criticised for its fairness, and where he did not attend and denies the allegations on the one hand, and on the face of it, unequivocal assertion by the British government that he is a war criminal on the other. It seems to me that those are two quite different attacks on his reputation, obviously with the same origin, but the latter seems to me, with some justification, is a very much more damaging and serious defamation because of the source and because of its unequivocal nature in the knowledge of the nature of the tribunal and the circumstances of the conviction. And it seems to me that left standing would be extremely damaging to him, and the finding of the High Court that was not justified would be a great benefit.
Yes, well, my Lord, the learned judge took all of those matters into account. That argument was advanced by my learned friend before the learned judge. He took all of that into account. He was fully aware of all of those matters, but nonetheless, as he makes clear in his judgment, nonetheless concluded on the Jamil ground that it shouldn't be allowed to proceed. Now, although we do say it is perhaps important to look at the words complained of, because they are in a footnote, and we say that is of some significance. They also make it clear that the appellant was convicted found guilty following a trial in absentia, and then there is the link to the Channel 4 report. Now, of course, I accept the ruling of Mr. Justice Tipples that for the purposes of deciding meaning, one can't look at the link. Whether or not that precludes one taking it into account, that program into account in the way of the other materials is perhaps a different issue, but I won't try and argue that today. But it does make it clear it was a trial in absentia, and it seems to us that where a reader is told someone's been found guilty following a trial in absentia, that immediately raises a question mark about the nature of the conviction. But it has to be seen in the light of all the other material ones. And it also has to be seen in the light of the claimant's own evidence, which was before the learned judge, about the impact on him of the report. And we don't accept that it had the sort of profound impact that it seems to be accepted the other material wouldn't have already have or will continue to have. It is slightly paraphrasing the learned judge on a different issue, it is slightly trying to have it both ways, because it's not right from the evidence, to the extent the court can reach any concluded view on this or take into account, that footnote has made all the difference. And we say that's not surprising because it is a footnote in a very long and detailed report. It's very unclear how many people actually read it. The footnote, I mean, not the report. And it is made clear that it was trial in absentia, which we say does make a difference. So, my lady, my lords, we do say that it is appropriate and permissible to consider this issue and determine this issue on the basis the learned judge did at this relatively or early procedural stage of the proceedings, if nothing else, to ensure that further significant costs, not just the trial costs, but all of the preparation costs, are not incurred unnecessarily. I was addressing the three elements of the appellant's complaints under ground 6. I've dealt with the first one. I can deal with the second and third very quickly. The second one was that the learned judge had placed had placed emphasis only on the length of the cost of the trial. We do make the point that is not a ground of appeal, but that there's a disagreement about the emphasis placed by the judge. The judge took those matters into account properly. They were one of many factors to be weighed in the balance, and that's precisely what the judge did. Simply the appellant disagrees with the weight the learned judge applied to them and disagrees with the conclusion. The third complaint, namely that the learned judge had downgraded the importance to the appellant of vindicating his right to reputation, is dependent on ground 5 succeeding as to the Dingle ground, and I won't repeat my submissions as to why we say that does not succeed or ought not to succeed. My lady, could I then turn to ground 7? I'm running a little behind schedule, but I'll try and catch up. Ground 7. It's in the application notice. Well, it's in the amended application notice at tab 11, page C108. It's dealt with in the appellant's skeleton argument of paragraphs 53 onwards, and the respondent's skeleton argument of paragraphs 57 to 60. The appellant contends under this ground that the truth and or accuracy or otherwise of the criminal conviction would not be relevant to any, and therefore would not feature in the trial of his complaints of unlawful processing under Article 6 and 10 of the GDPR. My lady, my lords, we say it is important to note that this issue can only arise on the basis that the appellant's primary claims for libel and for inaccuracy under the data protection provisions are struck out. And the appellant contends that even if his primary and obviously most important claims, the reality is those are the critical claims, they're the real reason he's bringing these proceedings. But the appellant says even if those are struck out, his complaints of unlawful processing should nonetheless be allowed to proceed. We say, our simple response to this, we say, is that the appellant's arguments here are unreal, because as the learned judge held below, the court would inevitably, it seems to us, have to consider, grapple with, in the words of the learned judge, the truth and or accuracy of the appellant's convictions in the ICT even in determining his rump data protection claims. And the learned judge dealt with that at paragraph 83(1) of the judgment, which is at tab 8, page C84. And we've set out in the skeleton argument why we say they would still have to be considered. But I can summarise it in this way. We say the issues to be determined under Article 6 and under Article 10 would require consideration of the truth and or accuracy of the claimant's conviction, because that would be a relevant consideration in deciding whether or not the processing was lawful for the purposes of Article 6 and Article 10, in considering whether such processing was necessary, whether or not there was a public interest in it, whether or not the personal data had been manifestly made public by the appellant within the meaning of paragraph 32, and ultimately for the purposes of striking the balance which would have to be considered between the Article 8 and of the convention rights under Article 8 and Article 10 of the appellant, and the Article 10 rights of readers of the report. And so we say the only way that the appellant can make good on this point is to accept that if and to the extent that any issue arose as to what the truth and or accuracy of his convictions before the ICT, he would not dispute that. And that obviously is not going to happen for the reasons the court will be very familiar with. So it was entirely right for the learned judge to strike out on the unlawful processing complaints under the Hunter principle, but also on Jamil abuse, because the reality is once the libel claim goes and the primary data protection claim goes of inaccuracy, then it is very difficult to see any real benefit in the two remaining grounds for unlawful processing being litigated, particularly when, even if successful, they would have no impact on what could be published in the wider world. Now then turn to ground 8. This is the additional ground for which permission is sought. It's dealt with in the amended grounds of appeal, which are its core bundle, tab 11, page C108. It's in the appellant skeleton argument at paragraph 70 onwards, and it's dealt with in our skeleton argument at paragraph 66 to 70 onwards. This complaint is that the learned judge was wrong as a matter of law to dismiss, quote, of little consequence, end quote, that the respondent did not have Article 10 rights. As the court will be aware from our skeleton argument, we submit that permission should be refused because this is hopeless, but I'll deal with it in one go, if I may, rather than dividing it up between permission and the appeal itself. The key points we wish to make in relation to this are as follows. Firstly, the ground 8 says the judge was wrong to do what it's alleged he did, but it's dealt with in the context, in ground A, it's dealt with in the context of the Jamil abuse jurisdiction. And referring to paragraph 83.12 of the judge's judgment. Now, although I accept, and I made the submission earlier, that the learned judge's reasoning on Jamil abuse should be read together with his reasoning from the earlier part of the judgment. 83.12 is under the Hunter section of his judgment, to the extent that makes any difference. So we're not entirely sure why the appellant has characterised it as part of the Jamil abuse, but it may not matter in any event, the form of it. What does matter is precisely what the learned judge said on this issue. The learned judge was not, as is suggested by my learned friend, mischaracterising the appellant's submissions on this issue. All the learned judge was doing in 83.12, and the court may want to look at the relevant passage. It's at page C87, and it's the most relevant bit is the final paragraph of 83.12, immediately above 13. And the learned judge said, although Mr. Dean correctly said the defendant had no Article 10 right because she was a public authority, he rightly recognised this was of little consequence, since readers of the report did have an Article 10 right to receive information in the report. So all the learned judge was doing there was simply observing that although my learned friend was right to make the submission that the respondent did not have any Article 10 rights which could be brought into play for these purposes, that legal position did not make a significant difference. We contend it doesn't make any difference because Article 10 remained in play, and the learned judge had to take into account the principles under Article 10, and it remained in play because, as was accepted during the hearing, readers of the report, however many there were of them, or potential readers of the report, had a right, as guaranteed by Article 10, qualified right obviously, to receive the information. And so the Article 10 issue did, or the protection guaranteed by Article 10, was a matter which the learned judge properly had to take into account. The learned judge was not saying that the appellant's rights were of little consequence. The learned judge was simply making the observation that the respondent's lack of Article 10 rights didn't really matter, or that's what was of little consequence. And the learned judge was, we submit, plainly right that it was of little consequence because it didn't make a material difference. The fact that the respondent can't rely on, doesn't have rights under Article 10. The respondent can still rely on Article 10 because of the right to receive information. And we've set out in the skeleton argument the various authorities which we contend make it clear that the public's right to receive information as protected by Article 10 is just as important as the right of a person to impart information under Article 10. And therefore there isn't a different approach to be adopted or one to be, have greater weight than the other. The learned judge was right to take it into account. And therefore we submit that ground does not disclose an error of law, doesn't indicate that the learned judge took into account something he shouldn't have done, and is in reality simply a complaint about the decision reached by the learned judge. That's ground 8. So I've dealt with, I hope, all of the grounds raised by my learned friend, we say for all the reasons you've given, none of those succeed, whether as matters of law or fact, and particularly taking into account the approach the court will adopt in relation to reviewing a decision of a judge in this situation, that none of those should succeed. We also seek to rely on, by way of our respondent's notice, an additional ground, and that's at, if I could turn to that, our respondent's notice is at tab 2, and the additional ground we rely on is at page C17, and this is an additional ground which the learned judge didn't rule on, which we say is an additional ground for striking out the appellant's claim on grounds of Jamil abuse. And the ground is the claim should be struck out in accordance with the Jamil jurisdiction for the additional reasons that the claimant's conviction before the ICT of the murder of 18 individuals and the notoriety of that conviction can properly be relied on by the defendant in mitigation of damage, and in addition to the reasons set out in the judgment at 84 to 89, render the maintenance of the claim disproportionate and or not worth the candle. The learned judge declined to rule on that issue, but we do invite the court. To consider it, because we say if one takes that into account, there is an issue of law between us as to whether or not the ICT conviction can be taken into account and relied on in mitigation of damages. We submit as a matter of law we clearly can, although a friend says we can't. But we say if we're right in law on that issue, and I'll come to that in a moment, if those matters are taken into account by way of mitigation, that would result in, even if successful, the appellant recovering very low stroke nominal damages, and that combined with the fact he does not seek injunctive relief and what we contend are very substantial costs involved, mean that the Jamil test is clearly satisfied. The court will have seen from paragraphs 86 to 89 of the judgment that the learned judge declined to rule on this issue. We say it is clear, in accordance with the decision in Goody, that previous convictions within the relevant sphere of a claimant's reputation are admissible in mitigation of damages as evidence of general bad reputation. And we say that that principle applies whether or not it is a foreign conviction. And as I understand it, that's the real, well, as a matter of law, that's the real issue between us. Now, we contend there are decisions in which the courts have considered this issue and decided that a foreign conviction can be relied on in accordance with Goody, despite the provision of Section 13 of the Civil Evidence Act. And obviously this has echoes of the debate on the earlier grounds as to consideration of foreign judgments. We refer in the skeleton argument to My Lady's judgment in King. I won't go to that in detail because the court's already dealt with it, but we rely in particular, King is at tab 35, we rely in particular on paragraphs 32 to 33 and paragraph 38 of My Lady's judgment in that case in support of this proposition of law. And then we also rely on the observations made by Mr. Justice Warby, as he then was in the Hareth case. That's at tab 42. I won't go into details of the facts of that, but the claimant had been convicted in Tunisia, and the defendant wanted to rely on that, amongst other things, rely on that conviction by way of mitigation. It's dealt with at paragraph 37 of the judgment, page 1336 of the electronic bundle. Point 4, the fact of the Tunisian convictions. The fact that the claimant was convicted does seem to be something that may be pleaded in relation to the amount of any damages. It is a fact capable, if not admitted, of proof without undue expense or difficulty, which a court might consider to have some bearing on the assessment of damages. Provided the current status of the convictions is understood and agreed, as it is, there are no sound case management reasons for excluding it. I do not say that it would in fact serve to mitigate, but that is not the test at this stage. If the defendants wish to pursue the point, I see no injustice in allowing them to argue that it should play some mitigating role. And then we've included in the bundle the reference in by the learned authors in Duncan and Neal, referring to that, suggesting that it is like, for what it's worth, it's likely that a court will regard criminal convictions in foreign courts as admissible on this issue, and that's in the authorities bundle at tab 61. We submit that it is would plainly be admissible, the fact that the appellant had been convicted in the ICT, and because it not only relates to a relevant sector of his reputation, it is the sector, it is the very thing in issue, and it would therefore be odd, very surprising, if the court could not take that into account simply because it was a foreign conviction, despite the fact that the whole claim is based on that. And we submit, once that conviction is taken into account, and the circumstances of that conviction, then it must mean, even if the claim were successful, the claim of libel was successful, once that is taken into account, then damages would be vanishingly small, and certainly not worth the time, trouble, cost and expense of having these issues litigated before the High Court in England. Well, my lords, those are our submissions on the grounds and respondent's notice. Unless I can assist the court with anything, I'm going to try and finish before my time is done.
Thank you very much.
My lady, my lords, I certainly hope to finish up before lunch, hopefully well before lunch. I intend to deal broadly first with Jamil, with Hunter, and then with Jamil. Although there is some overlap, particularly in the arguments in relation to fairness and proportionality. Lady, Mr. Hunter made extensive appeal in his submissions in relation to Hunter to the flexibility of the jurisdiction. But he can't get away from, in my submission, the requirement that in order for the jurisdiction to be exercised, the court must be satisfied either that the claim brings the administration of British justice into disrepute or is manifestly unfair to his client. My lady, and there is clearly in my submission an attack, an appeal in relation to the judge's finding that the continuation of this claim would be an affront to justice. Mr. Hudson began his submissions by saying there was no such appeal in relation to that finding. The appeal is based on two grounds, the first two grounds. First, that he was wrong to rely upon the Bangladeshi judgment because that judgment did not threaten the coherence and integrity of the administration of British justice. And second, that he was wrong to fail to take into account the fact that the appellant did not have a full opportunity to contest the decision against him. That, in my submission, is an essential part of the administration of justice limb, as it would only be a threat to the administration of justice if the party seeking ex hypothesi to attack a previous decision had had a full opportunity of contesting it.
And I'm just going to, just before you get going, as it were, if you could refer us, we didn't look very much at, in fact, at the judge's judgment during the course of your submissions. If you could refer us in your reply to the particular passages where you say the judge fell into error.
Milady, yes, I was going to go straight to the judge's judgment next, to illustrate the point I just made. The reasons are begin at 83 on page C84. Broadly, 83.1 to 83.7 encompass the administration of justice limb. And then beginning at 7, the judge moves to the unfairness limb.
So you have nothing to say about his characterisation of your submissions or those of Mr. Hudson before then, or anything else. So we're focusing purely on the conclusions in paragraph 82.
Lady, I was going to take you to paragraph 59.
All right.
Mr. Hudson also argued that it would be an affront to justice if the claimant could, in these proceedings, argue his conviction was wrong. His complaint about the fairness of the trial should properly be, or should have been, argued on appeal in Bangladesh. In my submission, that betrays a clear misunderstanding of the judge, both of the submission and of what the trial might encompass. This trial, a trial of this claim, would not involve arguing or the court deciding whether the Bangladeshi trial was unfair. And the claimant is not seeking to argue to that effect in this claim. I made that quite clear to start off with. The intricacies, the peculiarities, I did describe them, of the Bangladeshi proceeding are one of the reasons I say why the English court coming to a different decision would not be an affront to justice. Then he does record, paragraph 68, Judge, my submission that there would be no question of administration of justice being brought into disrepute if the present claim continued since two different legal systems were in play. He records that at paragraph 68 and extend to paragraph 71. And there is no consideration of that at all in his reasons. And indeed, in my submission, one searches in vain for a reason under paragraph 83 as to why it would be an affront to justice, an affront to the administration of British justice to bring this claim. Paragraph 83.1 refers primarily to the data protection ground, although a flavour of my criticism of paragraph 59 comes in the final sentence. Final phrase of the sentence is sufficiently clear that in both the libel and data protection claims, the accuracy of the ICT's conclusions would need to be revisited. Indeed, Mr. Dean did not really question that this was the object of the proceedings. Again, that's simply not right. The object of the proceedings is to seek vindication from what the Home Office has published about the appellant. And I will take you to his evidence in due course, because Mr. Hudson referred to it. 83.
Mr. Dean, sorry to interrupt. Can I just ask on that? Because the Home Office, what they actually published was that your client had been found guilty of war crimes in Bangladesh. You rightly point out some of the procedures, unusual procedures of that tribunal, but that was because it was 40 years after the event. I mean, where does delay feature in this when we're now looking at it 50 years after the event? And I just wonder if, when you're looking at vindication and what you can get out of these proceedings, what sort of vindication do you get out of proceedings so long after the event where all the witnesses are dead and where there appears to have been an inability, because of lack of funds, to pursue proceedings more contemporaneously in 95 or 96?
Well, my lord, in my submission, delay does not come into it in relation to vindication. Vindication is sort of what the Home Office published in the report in 2019. There was a letter of claim in December 2019, and then proceedings were issued in mid-2020. There's been no delay in the complaint in relation to the cause of action complained of. Now, of course, it's right that the events of which the Home Office accused him were 50 years ago, but that's not Mr. Mueen-Uddin's fault, simply because a man in his 70s suffers allegations about his conduct in his 20s. That doesn't diminish the impact on his reputation, in my submission. Now, again, the delay might come in the interval between the ICT tribunal and a claim to be heard, a trial of this claim. You have my submissions that there's no evidence before the court that any of the witnesses, insofar as they can give admissible or relevant evidence from 2013, are no longer available. So there is a general assertion that there might be unfairness on the respondent because of that bit of delay, but there's no evidence to that effect. It's quite clear the Home Office just hasn't checked.
Thank you.
I was on the judge's reasoning. At paragraph 83(2), he says, while there can be an abuse of process where early proceedings were civil, I agree with Mr. Hudson that the courts are particularly vigilant to guard against the collateral attack on a finding of guilt by a criminal conviction. Well, I accept that within the UK system. That is what Hunter tells us and the other cases which you were taken to. It says nothing about my submission about the impact of a decision, a criminal decision, which is outside the coherent system of justice.
I'm not quite sure why relitigating something which has been determined in criminal proceedings has to be relitigating a British conviction in order to bring the British administration of justice into disrepute by that process of relitigating. And it's the relitigating that is bringing the system into disrepute, and that is happening in this jurisdiction.
Well, the mischief of relitigation, in my submission, there are two aspects of it. One might be a party being vexed twice, and you can see that in the res judicata authorities, and I'll take you to why they explain, for example, House of Spring Gardens, Owens Bank, and Parakou, which weren't taken to. The other mischief of relitigation, in my submission, is inconsistency. An inconsistency is only an affront to justice if its inconsistent decisions come by on the same rules of procedure by the same court or a court within the same system. There's simply no affront to British justice. The British judge comes to a different decision from a foreign judge. Particularly, and we can see how that works in this case, that the ICT proceed on the basis of no rules of evidence.
It might be more accurate to say, an affront to the system of justice. I mean, the word British is introduced in the context of Hunter because what one was looking at in Hunter were two decisions, potentially at any rate, on the same issue within the same jurisdiction.
Yes. Yes, well, I adopt that.
But an abuse has a... The question is whether the judicial system itself is being abused, regardless of whether or not one's looking at two decisions within the same jurisdiction or not. That's the overarching issue.
Lord, my lady, yes, I mean, that's what it comes down to, whether the claimant is using the judicial system for some sort of improper purpose, some purpose outside the usual way in which it should be used an abusive purpose.
And so far as the affront is concerned, it's what the ordinary person would think, looking at the particular litigation in question.
My lady, yes, and the ordinary person looking at two decisions by two English courts which conflict would say, well, one of them must be wrong. Something's gone wrong here. The ordinary person looking at a decision ex hypothesi by a libel court vindicating Mr. Mueen-Uddin and a decision by the ICT finding that he's guilty of the offences would find nothing remarkable about that. And the more one looks at the facts, at the detail, the less remarkable it becomes. The two headline points that Mr. Mueen-Uddin couldn't defend himself at risk of death, British public policy that he shouldn't be extradited, and the other headline point that the rules of evidence have been completely disapplied, the consequences of him not being able to defend himself, that he couldn't directly instruct counsel, his state-appointed counsel didn't even contact him, he couldn't put forward evidence such as that in the affidavit, which said...
But you're not maintaining that the ICT proceedings were unfair, as I understand.
I'm not inviting the court to conclude they're unfair. I'm saying that the administration of justice is not damaged in the eyes of the man in the street, the right-thinking person, because of the differences in relation to the ICT. And the
Well,
fact...
they might think that if we had a fair trial in the natural forum for the matter to be determined. I thought it's fairly crucial for you, isn't it, to say that the proceedings weren't fair?
Well, I was talking about Article 6 yesterday morning, and the lady stopped me, but he plainly wasn't able to take advantage of his Article 6 rights. They were not afforded to him. I mean, these are matters which the court can take into account without...
I didn't stop you, I just queried whether Article 6 convention rights were apposite when we were talking about Bangladeshi proceedings. The underlying issue is whether, and these are rights and protections which existed before the Human Rights Act was introduced. So they're just of general application.
Lady, yes, and one can see that in Crown and Jones, which I think is in the file, about the very rare circumstances where a British court will proceed in the absence of a defendant.
Well, when one's considering whether or not it's an abuse to relitigate an issue in this jurisdiction, I'd have thought this court could look at whether or not the claimants have had an Article 6 compliant trial in determining whether relitigating was abusive.
Well, it is certainly my submission he didn't have an Article 6 compliant trial. The reasons I've just given, he couldn't defend himself.
Whilst Bangladesh may not be concerned with Article 6 because it doesn't apply there, we are concerned with it.
My Lord, yes. As I said yesterday, Bangladesh is entitled to set its own rules, not asking the court to make a criticism of the Bangladeshi rules, to say it was unfair in that sense. But it wasn't compliant with British rules of justice, as embodied in Article 6 and the common law, and the obvious requirement that someone ought to be able to defend themselves, and that the common law and statutory rules of evidence should be applied, which mean that newspaper articles are not relied upon for the truth of their contents. And the judge proceeded, and Mr. Hudson's submissions proceeded on the basis that he was not asserting that the trial was fair. The court should proceed on the basis as if it might not have been. And that's as far as I need to go. It certainly wasn't compliant with Article 6 for the reasons I've not given. I've given. And that, in my submission, is at the heart of why it's not an affront to justice. And that point is just not addressed by the judge in this section of his reasons. 83.3, he goes on to refer to Eldawani and King. You have my submissions on those as to why they're very different. The primary one being that the court was satisfied of the truth of the allegations of which the claimant was complaining in each case. The judge then deals with Standard Chartered, which I accept is not particularly clear authority, but it certainly supports my position. He then refers to the Law Reform Committee. 83.5a, that's correct, as it doesn't take the position any further. And 83.5b.
Well, that was dealing with an argument that you'd raised. Section 11, Section 13 issue.
Yes, it was, my lady, and the suggestion was raised yesterday that look, whatever the Law Reforms Committee said, it may not be of too much relevance. And my submission is that it's a clear account of what the public policy is behind Section 13. 83.5b. He says that the reasons which deterred the committee from extending its recommendations to foreign convictions now look somewhat dated. Judgments are now regularly made as to the standards of criminal justice in other countries, thus extradition amongst other reasons. And that's a point in my favour. I rely upon that. And this court must, in my submission, assess whether the claimant, if the appellant received an Article 6 compliant trial. Because only if he did would it be in front or the same allegations to be looked at by a British court. And then the key conclusion is in 83.5b. Since the Civil Evidence Act would not apply, the consequences the Secretary of State would have to prove de novo that the claimant was guilty of the murders. The burden of proof reversed the data protection claim. That could still leave the defendant exposed to an adverse judgment on the claim in libel. Mr. Hudson described that as an affront to justice and manifestly unfair. I agree. And that there is no analysis in that section of the argument which I made to the judge and I've made to the court about the fact that the claimant's the conviction was obtained in a non-Article 6 compliant trial. Means that there's no affront to justice if and if the British court is asked to consider similar issues. If I can pause there and come back to the reasons and say a little bit more about the affront to justice point, because Mr. Hudson appealed to the so-called right-thinking person, the suggestion that they would take the view that the issues had all been properly litigated a long time ago in Bangladesh, that being the appropriate forum, and that the ordinary person, and indeed the court, should see this claim as some form of backdoor attempt by the appellant to undermine his conviction and secure some undeserved, I think it was described, vindication in England, which he couldn't obtain in Bangladesh. And that picks up, in my submission, the remarkable suggestion by the judge the appellant was trying to have the best of both worlds by remaining outside Bangladesh, but challenging his conviction. That's very close to an improper purpose argument, which was that kind of abuse was not alleged. But in the event, there's simply no basis on which the court can draw that conclusion, and there's simply no evidence for it. There's no attempt to seek to cross-examine the appellant on his evidence as to why he was bringing this claim. concern being the British government had chosen to accuse him of allegations which he consistently and publicly denied for 50 years. If I may, I'll take you to some evidence on this matter, because Mr. Hudson referred to it but didn't take you to it. His witness statement, his first witness statement, is at tab 2. I want just the final paragraph, which is page S43. And it's paragraph 85. I am in no doubt that the fact that the allegations were contained within a report of the Committee of the Home Office were published on the government's official website, and therefore bore the authority of the UK government, that had added considerable further weight and credibility to the allegations complained of in the minds of the readers. I was shocked and devastated that the government of the country of which I am a long-standing citizen, and to which I devoted 50 years or so of my life, through community work and public service, would treat me with such disregard. I was deeply concerned a great many people would believe the allegations made against me were true, because the Home Office had said it was so, and therefore felt I had no choice but to bring the libel complaint to vindicate my reputation. Claiming that's the evidence as to what the purpose of the claim is, there's no challenge to that, or could there be? The suggestion that the claimant is somehow seizing upon a non-privileged opportunity to bring a complaint which should have been brought in Bangladesh is simply unreal. I mean, the Home Office could have reported the Bangladeshi decision in a way which didn't adopt the allegations. If it felt it was relevant to reporting how extremism looks in England and Wales, there would have been ways of doing it. The Independent article, which my Lord Justice Dingemans picked up on yesterday, may be an example of how that could have been done. But what happened was that a clear allegation of level 1 allegation of guilt was made by the Home Office in 2019. After all, it was the Home Office, not the tribunal, which alleged that the appellant provided a link between the violence committed in 1971 and community leadership in East London in 2019. Those are the words used. Not simply a historic allegation, it's about Mr. Mueen-Uddin now. And while I'm on the words of the report, the sting is not at all tempered by the reliance which Mr. Hudson placed upon the words in absentia. And that could easily cut both ways. The ordinary reader might well understand that the appellant was a fugitive from Bangladeshi justice because he well knew the allegations against him were true and easily provable.
Well, it undermined that wording by using the phrase well established.
Lord, yes.
I mean, that's the British government's judgment on the material.
Yes. As Mr. Mueen-Uddin says, he was concerned that a great many people would believe the allegations against him were true because the Home Office had said it was so.
And perhaps the paragraph, it seems to me, in the judge's judgment, which I think you can criticise as potentially quite tendentious, is 83 7. And whether it's right to say that your client really was in a dilemma, doesn't seem to me it was much of a dilemma. A British citizen accused of war crimes in 1971 in a tribunal which could impose the death penalty and had done so. It didn't seem to me that's any dilemma at all. Then saying he was trying to have the best of both worlds, I thought you could say is a very tendentious way of putting it. But remaining outside Bangladesh but challenging his conviction, because he isn't challenging his conviction. And the next phrase, it's not open to him, well, that's the issue. and then the proper forum to decide whether the trial was so tainted is the appellate court in Bangladesh. It seems to me that's something which requires some analysis before being taken as read. What was the right of appeal, and was it realistic that your client could exercise it? And of course the last sentence is obvious, but I thought you could say the whole of that paragraph suggests a slightly unrealistic approach to what happened in Bangladesh and your client's ability to deal with it.
Lord, yes, I agree with all of what you just said.
Thought you might.
We're going to come to that. But there's a prior point in the penultimate sentence of paragraph 7, which you referred to. The proper forum to decide that the trial was so untainted by unfairness that the conviction cannot stand is the appellate court in Bangladesh. I say that's simply not an issue which the English court would try. It's not part of the pleaded case. It's not something that the English court would have to look at. And these passages are important in my submission because, if I'm right, there's no good explanation in the earlier passages as to how English justice would be affronted. Then one has to find the explanation here. And the explanation appears to be, well, he should have appealed in Bangladesh. And one could see perhaps some force to that if he'd simply decided to stay in England because he couldn't be bothered going and then couldn't be bothered appealing. But there's no evidence, the Home Office has sought to put no evidence before the court that he could have somehow appealed remotely. It seems extraordinary if he could have done. But there are several issues of principle as to why appeal would have been hopeless. The submissions I made about him not having an Article 6 compliant trial would not have been well founded in Bangladesh because they were all based upon Bangladeshi law, which provided for a death penalty, which provided expressly for trials in absentia, and which expressly removed all of the laws of evidence, the rules of evidence, even the local ones.
Mr. Dean, that may be a chance just to ask you this point, the question I'd asked Mr. Hudson about whether you accepted that the conviction in Bangladesh, whether fair or unfair, you say is immaterial, is relevant to the general reputation of the claimant for the purposes of Dingle.
Lord, yes. I can deal with the Dingle point now.
Sorry to take you out of your turn. It's just I did want whenever it's convenient for you.
Well, the essential point is this, my Lord. In my submission, which I made yesterday, is that foreign convictions are not admissible on Dingle grounds. That was for two reasons. One, that they don't prove the truth of the facts behind the conviction, as English convictions do. And secondly, that one cannot assume that the ordinary reasonable reader reading about a foreign conviction would therefore think substantially less of the person who was convicted, precisely because a foreign court may not have the Article 6 safeguards which the English court has. And the more...
and what about... Oh, sorry to interrupt. And what about the Wikipedia entry, again? Is that something that can be part of general reputation, or is that because it picks up that the inadmissible, you say, foreign conviction, one can't have regard to it?
Well, in my submission, paragraph 83.12 of the judgment is extraordinary. The judge contrasts there damage done by a continuing Wikipedia entry with vindication given by a judgment in an English court. In my submission, they're not remotely comparable, whatever the position on the law. But the Wikipedia entry would not be admissible in my submission, the reasons I've given, because of Dingle. The continuing publication is not admissible, and that is what Mr. Justice Warby says in the show, in the passage which I cite in my Skelton argument. The complaint was that it wasn't directly on point. The point there is that the court applies the Dingle principle which generally is seen in relation to previous publications, to continuing publication. Now, the Wikipedia entry may well continue, but if we're getting into Wikipedia, it's something which is constantly updated. I would expect the Wikipedia entry to kick off with a decision of the English libel judge. The English libel decision on this hypothesis, which is that the defence of truth fails, would be widely reported, one could expect, in this jurisdiction and elsewhere. And in those circumstances, the suggestion that these little bits of earlier publicity mean that, as I think it was put, the claimant, the appellant would receive minimal damages. Outcome of the claim would have no impact on the claimant's reputation. Nominal damages or vanishingly small damages is simply unreal in my submission. And one could compare that with the Karpov situation. I'll come to Karpov, the law on Karpov shortly. But there you can see there are, I think, 16 different international organisations, including the US government.
Well, there are two questions. I mean, the first question, preliminary question, is whether you are right as a matter of law in your submission on the basis of the authorities you referred to. And then the second is what I might call the degree question, whether Karpov was a different type of case, but they're not the same question.
Yes. Well, I mean, they feed into each other in this sense that one of the reasons the court does not rely or does not take into account previous publications, particularly when those publications might be privileged, and particularly when when there's a defence of truth, is that the defence of truth will go some way in towards correcting the damage done by those publications. One of the reasons why they don't come into account. But I accept they're distinct questions. Lady, my lords, may I just say a bit more on Hunter before I move to a bit more of Jamil, because we are on a rather overlap here on the admissibility of earlier or continuing publication. Mr. Hudson has to rely upon what the judge says about previous publication in his Hunter section in order to shore up the Jamil decision. He was very reluctant to admit my reliance on what the judge said about Article 10 rights of the defendant in the Hunter section, but may not matter too much. There is an overlap there, and I say the same principles apply because of the reason behind Dingemans, which I'll come to shortly. But just to finish on paragraphs 83, 6 and 7, because this is the basis on which, in my submission, the judge finds there being an affront to justice, rejecting the full opportunity aspect of Hunter. And I accept, of course, that Lord Diplock's words mustn't be read as a statute. But to put it like that ignores the fact in my submission that a full opportunity to contest the requirement, to contest the previous decision, is an essential building block to finding whether the administration of justice is brought into disrepute if the same issues are looked at by a different court. Slightly separate point on the reliance on foreign judgments. Because this is where the affront to justice is said to come from, the judgment. And to mention simply this point, that House of Spring Gardens, Owens Bank, I say the Parakou case, which wasn't referred to orally, but was in the respondent's skeleton argument, are all actually about the unfairness limb, because they all involve relitigation between the same parties or their privies. Mr. Hudson took you to the passage in the judgment of Lord Justice Stuart Smith in Spring Gardens, where he said that even if there was not an estoppel, there had been abuse of process for the defendant to relitigate the very same issue in the English courts upon which they failed in Ireland. Public policy requires there should be an end of litigation. A litigant should not be vexed more than once in the same cause. In Owen's Bank, there had been two previous cases between the parties, in France and in St Vincent. That was the basis on which the court held it would be an abuse to continue in England. And the Parakou case, I'll just make the point that the Hong Kong court found, as a matter of Hong Kong law, the parties in the Hong Kong case were privies to the parties in the previous English arbitration. So that's how the Hunter jurisdiction applies in its most obvious case. It comes in to foreign decisions. It comes in the question of fairness, where parties have previously litigated issues between each other in a foreign jurisdiction. And one searches in vain, I say, in this judgment, for a reason as to why it's the tribunal decision which leads to any unfairness on the Home Office. You have my submissions about all the unfairness complained of is the fact that the Home Office would have to try and prove allegations which it published about events 50 years ago. The tribunal, if anything, reduces the unfairness. When Mr. Hudson was asked this morning what evidence he'd rely upon at trial, all he referred to was documentary hearsay evidence, the ICT judgment, the dispatcher's programme, and other publications. So the ICT reduces fairness, if anything, not only because you rely upon the material as hearsay, but it lists all the names of the witnesses. The unfairness in my submission, if the appellant were not allowed to proceed, comes down solely on him. When he couldn't have resisted the claim, the prosecution at risk of death, he couldn't have appealed at risk of death, and any appeal would have been hopeless. And in those circumstances, I do very much adopt the proposition put forward during argument by Lord Justice Phillips that paragraphs 83, 6 and 7 are simply unreal. That the appellant was facing a dilemma about whether to go to Bangladesh and risk his neck or not. The fact that he chose not to, in my submission, should not prevent him suing someone who alleges that what the tribunal said was true. And the consequence of the Home Office case is that anyone could allege that Mr. Mueen-Uddin was a war criminal in any forum, and he'd have no remedy. I'm going to address the next topic under Jamil. As I said, there's some sort of crossover, because this is about proportionality arguments, which seem to come in under 83.8. It's highly questionable whether proportionality in this sort of sense really affects the decisions for the court, whether there's a affront to the administration of justice or an unfairness, a manifest unfairness on one party, which I say must come about from being vexed twice. Proportionality might come in if there are two decisions within one system. If the English criminal court has already decided the issue, then it would be a waste of public funds, one might say, for the English civil court to decide it again. That issue doesn't come in play when you've got courts outside in different jurisdictions. And so I'm on proportionality, unfairness. Just to slightly develop the point I made yesterday about and it was the point my Lord Justice Phillips made this morning about there being no evidence before the court as to what the trial might consist of. I mean, not only is there no defence, but there's never been any correspondence. There was no response to the pre-action protocol letter of claim, which said we want to prove murders 6, 5 and 10 and we'll rely upon witnesses X, Y and Z. There's never been anything like that. It's useful to look at what Miss O'Mahony did say in her evidence, which again Mr Hudson referred to, but I don't think he took you to. Firstly to paragraph 20, please, page S15. As the Secretary of State is applying for an order which would result in the summary disposal of the entirety of the claimant's claim, it's not considered proportionate for a defence to be filed. In the event the application is unsuccessful, it's necessary to file a defence. The Secretary of State currently intends, very careful wording in my submission there, it's not said to be a settled intention, nor could it be without any examination of what evidence there might be. Defence of truth, amongst others, and to deny the accuracy principle. It would be necessary for the court at trial to consider and determine the same issues determined by the ICT, namely, and in broad terms, that phrase is doing an awful lot of work here, whether it is substantially true or accurate that A, the claimant committed any or all offences which he was convicted by the ICT, and B, well, B is no longer an issue. So that's what is said, that's all that is said about what the ambit of the trial might be. And then, please, to paragraph 53 of page 23. Beginning at the middle of the fourth line down. Notwithstanding that many relevant witnesses are likely to be unavailable because of the passage of time since the events in issue, it can reasonably expect that a substantial number of witnesses would give evidence at trial. The question arises, which is it? Is the unfairness caused by the fact that the witnesses wouldn't be available, or that a substantial number of witnesses would have to give evidence? It's apparent there's simply been no investigation by the Home Office as to what the position would be. And in those circumstances, there's simply no tools or no evidence on which the court could determine whether the trial would be proportionate or not. And there may be some Jamil cases where issues of proportionality can be tried without a defence. A very low publication case, the publication of trivial allegations, or allegations were made by a source which didn't merit respect. None of those are this case. So in my submission, it was a clear error of law by the approach or principle by the judge to rely upon the broad submission, as he described it. The case would be long and costly to try. My lady, my lord, I want to move in a little bit more detail to previous publicity now, particularly given what the question raised by my Lord Justice Dingemans. Because that was mentioned in the section of Jamil, but Mr. Hunter sought to bring, sorry, in the section on Hunter, and Mr. Hudson, I'm sorry, have I been calling you Mr. Hunter all day? But Mr. Hudson sought to bring it in on the section on Jamil. It is important in my submission to remind oneself of Dingle. This was a case where there'd been seriously defamatory allegations stated in Parliament. Those allegations were reported on privileged occasions by a number of newspapers. The Daily Mail then reported those allegations in a non-privileged way. In the words of Lord Denning, it put some meat on the bones and had to take responsibility for the whole joint. I'd like to draw your attention to what Lord Morris says. Tab 2, Electronic Bundle 56. Sorry, that's not 56, it's hard copy 55, electronic 56, I believe.
And which tab did you say?
Oh, tab 2
Tab 2.
in bundle 1. In the second sentence of the second complete paragraph, and was the judge warranted in assessing damages on the basis the respondent came to court with a damaged reputation? Cannot be denied that textual publications in newspapers of the report of the Select Committee would occasion highly unpleasant and prejudicial publicity for the respondent. If such publications were in good faith and without malice, the statute of protection would apply. If, however, there was publication of defamatory matter in respect of which there was no statute of protection, then damages should have been awarded in accordance with a well-recognised general principle. It refers to, included in this rule is that the defendant may, in order to mitigate damages, adduce general evidence to show the plaintiff is on a bad reputation. It ought not, however, to avail a defendant to prove that the plaintiff has been under a temporary cloud of suspicion when the success of the plaintiff in libel proceedings demonstrates that there need never have been any such suspicion.
Well, I don't think any of these propositions are in doubt. The question is whether you can translate them in the light of the authorities we were shown by Mr. Hudson to preclude reliance on them in the present context.
Milady, yes. Well, I'll go straight to Harath then, please. Bundle 5, tab 42. Because Mr. Hudson's submission, and indeed the footnote in Duncan and Neil is just wrong on this. Bundle 5, tab 42. Draw your attention first, please, to paragraph 21, page 1333, electronic, 1332, hard copy. You see from paragraph 21, the claimant's application attacks three aspects of the defence. First is the plea of general bad reputation in paragraph 8.4. This formed part of the defendant's pleaded case in allegation of the answer to the allegation of serious harm, alleged to infringe the rules on what may and may not be pleaded by way of general bad reputation. But then the most important paragraph to understand this decision is at paragraph 26. As to the convictions, there's a reference to the evidence and submissions no longer relied upon. The claimant's evidence on these matters is also unchallenged. In light of that online reference to the matter has been removed, the draft amendments also include the deletion of the assertion that the claimant has a general bad reputation, although some paragraph that contain that assertion is retained. And one can see that in page 1335, hard copy 6, electronic. Where the amended paragraph 14.7 is set out in the middle of the page, and one could see struck out the reliance of the words and the claimant's general bad reputation. So the convictions are not being relied upon in relation to general bad reputation. It's right, of course, that Justice Morby says, paragraph 37, that he's not, on case management grounds, going to remove reliance on the convictions because they might, or the judge might consider they have some bearing on the amount of damages. He doesn't explain what that bearing might be, but it might perhaps be seen to be on distress. The argument could have been advanced that it's not so distressing for an allegation to be published, which has previously been published, than it is for one to come out of the blue. Might have been the argument. But whatever it is, he's not relying upon them for general bad reputation. So I say the footnote in Duncan and Neil, which comes in the passage in relation to the Goody exception, is wrong, because Harath's not on point. The other case then is Karpov, And although Mr. Justice Simon didn't see it this way in his judgment, it is best seen as a potential exception to Goody to Dingle along the lines of Goody. That's the way it was seen by Mr. Justice Warby in the show. He says that at his first instance decision, bundle 5, tab 41. And page 1319, paragraph 155, please. Actually, it's paragraph 1. Yes, 158. Refers to the argument advanced by.
Sorry, the paragraph number.
Oh, I'm sorry. 158. Page 447 of the judgment. He refers to the argument that the impact on other publications and reputation may be relevant and admissible in the Jameel context, whatever the merits of Dingle. Reliance on a number of cases, one of which being Karpov, and the submission recorded that the existence of numerous other publications of similar effect was relevant as to whether the publications complained of constituted a real and substantial tort. Mr. Justice Warby said this at 159, "I'm not persuaded that either submission accurately reflects the law in this area." He deals with Kashka and Subotic, which are not relied on. He says this about Karpov. In Karpov's case, such impact does appear to have been a factor, but the key publication was a public denunciation by the US authorities, which may be within the exceptions to Dingle. In any event, these decisions predated the entry into force of Section 1 of the 2013 Act. I find it hard to see how the pursuit of an action in respect of a publication that's caused serious harm to reputation can be characterised as an abuse on these grounds. So Mr. Justice Warby saw the decision in Karpov as an exception to Dingle, which may be within the exceptions to Dingle, is what he said. Rather faint approval, if any. But that is contrary to Mr. Hudson's submission that Karpov is solely about abuse and one shouldn't apply the Dingle rules worked out in libel. Then to look at Karpov, please, bundle 4, case 36.
And is it your submission, just so that I've got it accurately noted, that the Channel 4 dispatches would be not evidence of general reputation, but would be the wrong side of the Dingle line, as it were?
Well, yes, my lord. In my submission, the 1994 television broadcast is clearly the wrong side of Dingle. It doesn't have any of the authority of any court. And it doesn't have the authority, which there certainly is, in relation to the publications in Karpov. First, perhaps, in Karpov, I can draw your attention to paragraph 32.
Could you just give us a page reference?
Oh, I'm sorry, it's 1038 hard copy, 1039 electronic.
Yes.
Paragraph 32 sets out the very many headings which there were in the particulars of justification. This is a case where there's a very long and detailed particular justification, or truth as we now call them. And then to 77, please, which is where the unstoppable torrent of international condemnation is set out. And one can see there a long list of very high-level respected organisations which have made the allegation that the claimant was guilty of the conduct which he was complaining of, including the OSCE, United States Legislature, European Parliament, Human Rights Watch and Amnesty International, who come into our case, of course, as bodies who criticise the safety and thoroughness of the ICT. Now, Justice Warby wasn't asked to decide this in the show, and his comments that they may have come within the exceptions to Dingle aren't authority that they do. He took a different view to Mr. Justice Simon, who thought Dingle wasn't relevant. In my submission, properly understood, they are ruled out by Dingle. Because they are previous publications to a similar effect as those complained of, and they are not within the exceptions to Dingle, namely convictions by an English court, or perhaps the one which is slightly mooted otherwise in, I think it's Sunday and Waters and Sunday Pictorial, statements by judges made in judicial proceedings. That's the submission of law. But then there's the submission which comes back to the facts. That looking at this, described as an unstoppable torrent of international condemnation, one can quite see how the submission, as a matter of, I think it's described, practical reality, the decision of an English judge would have little effect on the reputation of the claimant, would have some force. That's just not the situation here when you're comparing the decision of an English judge with a Wikipedia entry. Just give me a moment, please. Final point, my lady, my lords, which is on the extent of publication. Mr. Hudson made much about it only being a footnote, and maybe lots of people didn't read it. Well, there's no evidence before the court people didn't read it. But there is evidence before the court that people did. It's in the particulars of claim. The pleading is that the claimant was contacted by numerous colleagues and associates who had read the report. The paragraph is I'm sorry. Paragraph 10 of the particulars of claim, page C95. My lady, my lords, unless I can help you further.
No, thank you very much. Well, we are obviously not going to give our decision or our judgments now. Can I thank both of you for your very helpful oral and written submissions, and also those sitting behind you, because we know how much work goes into preparing these cases at every level. We're very grateful to everyone concerned. When the time comes when we have our judgments are ready in draft, they will be circulated for the correction of obvious errors and omissions, not for the purposes of re-argument. We would invite the parties also to endeavour to agree a draft order for our approval before the hand-down, which will be done remotely, as is now normal. If we require any further assistance from the parties, either in the interim or after the draft judgments have been circulated, then we will ask the parties for submissions in writing. That's all we need to deal with now, except to say thank you very much. All right, thank you.
Right.